Right, let me share my screen. Hold on. Can you see my screen?
Yes.
All right. So we'll start the lecture now. Law debate, simplification, and the complex. Thanks to the MNIDC team for coming up with that. So I guess we'll start with just like introduction in regards to how law debates usually look like. If there are anyone out there who's unsure of what it actually is. So there are things like the debates about the criminal law, which means that when it comes to what ought to be a crime, there are debates in regards to that as well, or the criminal justice system, whether or not that the criminal justice system should be reformed, for example, what kind of reforms are the best ones, the best type of reform. And in my opinion, international relations is also a law debate in some sense, given that it's about the ability for either like international organizations to operate, or whether or not it's lawful to some extent, principles of sovereignty. So to some extent it is about the law, and then also just either individually or in combination with one another. There are also debates about the principles of law or the purpose of law, things like retribution, rehabilitation. I think these are things that would be the buzzwords in law debates or legal debates usually. So I'm pretty sure a number of you have have found these motions in previous tournaments. All right. And so the things that we are going to cover in this lecture is basically these 5 things. There are also obviously more explanation below that. So we're going to learn about the purpose of law, morality and law, the question of what makes a crime, what ought to be observed as a criminal conduct, for example, and whether or not this is something that's justifiable, as well as the 5 principles that we talked about earlier about rehabilitation, retribution, etc. Right, so on to the purpose of the law. So this is just a report I found from other materials in regards to law debates, which I think is interesting because the purpose of this report was basically on the common law debates that we usually see. Things like debates about prostitution, for example, legalizing prostitution. Should you only legalize it, or should you decriminalize it, for example, or perhaps just banning it altogether? These are all questions that are usually found in law debates. So in this particular sense, I guess the definition in regards to what the purpose of the law can vary, but this was just one of the more popular definitions. So it's basically to encourage good behavior and to deter bad behavior. That would be the essence of what the law ought to be, or what the law should do in regards to how society perceives it. So specifically though, in regards to this definition, it says that it's to preserve public order and decency, to protect the citizen from what is, offensive or injurious, and to provide sufficient safeguards against exploitation or corruption of others, particularly those who are especially vulnerable, i.e., any other socially vulnerable groups. It is not the function of the law to intervene in the private lives of citizens or to seek to enforce any particular pattern of behavior further than is necessary to carry out the purposes we have outlined. So what this essentially means is that there are a few limitations in regards to what the law can and cannot do. And that's why I think also this definition is interesting. Okay, hold on. If there are any questions, you can just stop me anytime and I can answer the question. All right. Now onto the question of morality and law, which was the second thing that we were going to learn in the next slide thing. So morality and law is morality and law coexist. It supports each other's networks in the forms of either societal acceptance of certain norms, and then perhaps that those norms can also diverge into moral, in the moral sense, talking about the normalization of certain actions over others, and also perhaps incentivization of good actions in some form and manner. So in regards to this, there are a few basic ideas that you ought to know when it comes to morality and law. So either number one, that it is every human's right to be free from harm from others. No one should be a victim for a third party harm. Is there a distinction between allowing you to be harmed and harming you? This is also a question that's normally posed in law debates as well. But this is this distinction between being harmed and harming you. So in regards to this specifically, just in regards to its meaning, it doesn't really matter, but just as to a point where you are harmed and you did not consent to the to those particular harm, then that's something that you should be free of from others. Secondly, on the idea of whether or not the condemnation of the most of society is enough to mean something is illegal, so because it depends on moral standards of society, and in different areas, geographical proximities, they would necessarily have different standards in regards to what's moral and what's immoral anyways, and it's very subjective. So they are, for example, whether or not we should outlaw adultery, given that this in some regions are considered as a very immoral act, and a large chunk of society truly believes that this is something that's immoral. And given that, the law and justice system ought to be perceived to be just as well, in that regards, then it should also be punished with more severe punishments compared to perhaps other forms of crimes, because that, it's an immoral thing to do in those particular circumstances. But there are countries that did not, find adultery, for example, as a truly immoral act. So in general, given that the law should reflect what the society's interests are to some extent, given that, it cannot be separated from one another, because if not, it would be a condition of where individuals are unable to truly express their choices, as well as enjoying a certain level of freedom. So obviously it has to interconnect with one another. So those are also questions that you're going to find when it comes to debates about morality and law. Sorry. And then there's also the concept of whether or not law should be paternalistic to even begin with, and if they should, how far should they be paternalistic? Paternalistic is basically acting like a parent. In this instance, it's the paternal figure, the father figure of citizens, for example, in order to curb or control themselves from perhaps injuring themselves or making actions, though perhaps consented to, but not necessarily the best form of actions, uh, uh, just in regards to protection to oneself and prevention of, hurt and injury. So things like taking drugs, for example, or whether or not this is something that you deserve to do or have the right to take, for example, compared to whether or not this is going to be harmful, and thus state perhaps might impose certain amount of limitations, legal limitations and sanctions. Caught consuming some of these drugs, but the perpetrator of the crime would necessarily be the dealers or like the criminal gang that runs the whole thing. So there will be the perpetrators of crime. So would there be a need for you to have mitigating factors, for example, in regards to the situations that those individuals specifically are in? So the punishment metric will also something that will be discussed whether or not it should be flexible or not to match perhaps the morality or what is the most moral thing to do in this instance. All right. So now we'll move on to what makes a crime a crime. In the more legal answer would be two things. The first is actus reus and second is mens rea. Actus reus is basically that you have done an action that is criminal in nature. So it's the guilty act, whilst mens rea is intention. So this wouldn't be of much use in debates. But just knowing that this would be the formula for a crime to occur, I guess is important, especially in law debates. So in regards to the concept of actus reus, laws generally aren't designed to punish thoughts. So there must be an injury or there must be some form of harm that has occurred, something bad basically. So even if you intended something bad, for example, to happen and someone else did it before you did, you're still not a criminal. So the reason for that is because you did not actually, if we're talking about like murder, for example, perhaps you have had thoughts about killing this person. So maybe that would mean that you have some intention of killing that person. But if you did not actually kill that person and someone else did, or by accident or whatever, that does not mean that you are a criminal because it's an incomplete transaction, moral transaction, given that you haven't actually committed the criminal wrongdoing to even begin with. So secondly, if I sell a car that I think is faulty to someone, but it turns out it's not, you had the intention and perhaps also had some form of actions to necessarily cause harm, given you're lying to this person about your car, but turns out that there's no harm that occurred. So you meant to commit a crime, but you didn't, given that the car is not faulty anymore. And so you're not defrauding or you're not frauding that person. So whether or not this is something that should be an acceptable action to a point where it can be normalized in society, given that this might be a loophole in the law, or whether or not that the law should be strict in regards to the standards that ought to be used in regards to perhaps different crimes and what would prove what would be considered as a criminal wrong or the guilty act in itself. So given that, when it comes to drugs, perhaps that are going to be more strict, given that, the impending harm of allowing for drug abuse and allowing for social problems that comes from addiction, for example, would not necessarily be the most moral thing to support. So in some instance, maybe you want to create larger deterrence, for example. Maybe that's a thing. But it does happen in most states, actually, when it comes to the war against drugs. So, okay. And the thing about knowing that the law is formed by a guilty act and a guilty intention, I think what the benefit that it gives you is that you are necessarily able to see the debate in a way where you would prove that there is a guilty act or there is a guilty, some form of guilty intention, for example, perhaps in your principal argument. Just, maybe it's a value judgment debate and that's something that you have to do in that debate, for instance. So you need to be able to answer those questions. And because if not, then it will be unclear as to why something should be banned or something should be decriminalized, for example. Banning would mean that you have to say that this is something that is wrong, immoral, causes some form of harms. So obviously that's why you want to ban these stuff. Or when it comes to decriminalization, perhaps you want to talk about the victims, for example, especially who are not intentionally doing the criminal actions, but perhaps are coerced to do so. So those are the kind of things that will also have to be proven. So I think just knowing the legal aspect to some extent is important to be able to see that that link that should be clarified in the debate. Right. And then yeah, and then we'll also gonna talk about mens rea, or the guilty mind, the guilty intention. So the aspects that you have to know basically is that there should be intention. Intention is, like a thought. But obviously there are like few levels and caveats to what kind of thought would then be considered as criminal intention or a guilty mind. But just basically knowing that you would have to be not coerced or free consent, for example, and that perhaps that you are not victims of circumstances. So if it's going to mitigate your sentence, even though you're probably still guilty of it, would then help to see whether or not certain sanctions, criminal sanctions, are justified. Yeah, so that's also important to know. Is there a reasonable burden on this person to know the likely results of the actions? The foreseeability, because to some extent it might get to a point where you have to connect between what's foreseeable, and once that particular harm occurred, for example, whether or not those are the kind of things that they ought to be liable for. Yeah. And then it will also have to know about individuals who did not intentionally do something. So like mistakes, for example, as I mentioned, apart from being coerced or being victims of circumstances, if you're mistaken that theft is not a crime and you're still guilty, whether or not you're still guilty, it comes to again the idea of retrospectively whether or not this should be applicable. So if I am mistaken that the object is mine, should I be guilty? That's also a question that, when it comes to questioning the intention or the guilty intention and the criminal intention of a person, what would necessarily set the standard of a guilty intention, a criminal intention? So the answer to this question is basically that in most instances, ignorance would not be an excuse to a crime. So even if you're mistaken about the law and the application of the law, you would still have to be punished to some extent, given that information about this particular law is already out there. So it's your ignorance that have caused you to not know these things, and thus that why you're still guilty of those actions. Right. All right. Ignore the picture. And now we'll be moving to the 5 principles. Before I move on, are there any questions? Right. I don't think there are any questions. So we'll move on. So now in regards to the 5 principles, and these uh, these things, whilst usually are used as buzzwords in debates to try to convince the judge to believe that you are perhaps the team that provides more analysis, is sometimes that they don't actually analyze those things. And I understand that as a strategy, perhaps, you want to method dump and then, uh, just want to control the variables of the debate. But I think there are a lot of things that can be said, especially in regards to these principles that can be applied in law debates in different ways or in combination with one another, that would be interesting to do in a debate, and thus then setting up that you're actually analyzing those things. Okay. So one of the key principle regards to law or the purpose of the law, or why the law is necessary, for example, one of it is retribution, and retribution is basically wanting someone who have committed a wrong to suffer some form of harm as well to some extent. So criminals ought to suffer in some way, given that they've committed wrongdoings, they've probably breached the rights of other individuals and caused third-party harm, and or taking improper advantage or inflicted some unfair detriment on another individual, and maybe also breach the social contract, because nobody wants to be attacked, and that's an agreement everyone agrees to in regards to law. That's why they criminalize certain actions, but for them to have committed this thing again, and then making victims suffer some form of harm and mental trauma as well. So what that necessarily means towards the protection of society, to some extent, that will be interconnected with the concept of protection and deterrence to some extent. So breaking of social contract will also be considered as for something that ought to be punished with something, and that's retribution and retributive justice. And then that victims to take agency from wrongdoers as well, to be able to get closure, because a person knowing that the perpetrator of a crime that they have been a victim of, for example, they know that this person is no longer out there hurting other people. They know that this person is now being punished for their actions. They are suffering some form of damage for the hurt that they've caused you, and also to the society in general. So that would be something that would be taken into account, especially in regards to retributive justice. Another example of this would also be when it comes to punishments for violent sexual crimes, for example. So there are like the feminist aspect of this, where feminist movements are advocating for retributive justice, especially in regards to violent sexual crimes. And in those instances, it's also something that would be considered as the most just and retributive form of justice, given that it allows for harsher punishments or longer prison sentences, for example, for violent sexual crimes. But violent sexual crimes usually are punished with life sentence anyways, life sentence. Yeah, not death sentence, but uh, you know, prison for life, which usually is just 25 years. But especially in regards to whether or not those punishments, those years are enough, is something that's also a question of whether or not the victims, for example, can feel closure from. Yeah, that's also an aspect of retribution or retributive justice that usually occurs in legal debates. All right, but obviously, there are going to be disagreements in regards to, a debate. You have to rebut some of these things, so you might be able to argue that deterrence or retribution is good, but it does not necessarily mean that your idea will be foolproof. Obviously, that for a discussion to happen, you ought to know the problems with these principles as well, so that you can form a complete analysis in regards to retribution in itself. So to apply that to debates, it might look like even ifs, for example, or strategic concession of certain articles in regards to the motion. So those will be also something that you can do, especially if you are able to recognize problems from the principle itself. Right. So it's the idea that two wrongs don't make a right, as a converse or inverse of an eye for an eye, for example, whether or not something ought to be can or is the most just thing. especially in regards to certain criminal actions, perhaps that they've committed a criminal wrongdoing, but then to, as a state, for example, given that the law is implemented and is sponsored by the state, so whether or not the state can commit this particular wrong that part of society have created, for example, whether or not they have the right to commit those things. And especially, I think the clearest example is in regards to death sentence. Punishing a convict of um, of life in itself, and obviously proponents of the legal world that are perhaps are more progressive, they would necessarily argue that the state does not have the right to take away life from someone. They were not given the power to take life from someone, given that they are there to perhaps manage actions of individuals, but they do not have or that their authority and their obligation as well does not extend to taking away the life of someone. So that's why that's not an option for a state to do, and that's why some states also no longer do death sentences. So that's also something that is usually questioning regards to retribution, because death sentence would be the most, I guess, if we're talking about the concept of an eye for an eye, would be the most appropriate or proportionate thing for a person who have committed the most heinous forms of crimes, like again, to the example of violent sexual crimes, for example. So there are also questions regards to that. Right. Whether or not it's backward looking and whether or not it focuses on creating more good, for example, or when it comes to the comparison between harming someone to create some form of good, but creating harms to mitigate previous harms, as well as a scenario that makes more sense in regards to whether or not retribution in its application would necessarily carry out some form of good at the end of the moral punishment or transaction of for breaching the freedom of some individuals and then for that to be temporarily taken away. Whether or not this actually achieves the idea of closure for victims, for example. Given that it's subjective, given that people react or respond to how they deal with their life experience differently, so it might be that there are differing standards as well. And then how it can also brutalize society in extreme cases. People take a form of pleasure in the suffering of others, especially when it comes to retribution, given that you are basically punishing the convict, right? And there is a sense of not only moral superiority, but also, I guess, a pat in the back for being the moral person in society. And this is a form of conditioning, I guess, that law does in regards to how people ought to follow the law. But whether or not this is something that's justified for individuals to suffer from the indignity of becoming the tool to achieve a moral outcome. Yeah, and there's also victims of irrationally barbaric in these situations. Again, when it comes to proportionality of certain punishments, whether or not it should be literal in its sense, an eye for an eye, and if it's literal, then what does that mean in regards to justice? Those are also instances that is problematic when it comes to retribution. Sorry. Okay, and now we'll move on to rehabilitation. One of the 5 principles for why law is necessary. Some people believe that the purpose of law is to, not I guess law, but criminal law, is to rehabilitate individuals who have committed certain wrongdoings. It's basically the idea that all of these individuals are usually victims of circumstances, so they are mitigating factors that's applicable to almost everyone. So the state ought to then try to change not the the uh, the physical state of punishments, by inducing suffering for people who have convicted a certain crime, but precisely then try to cater to the intentions of those individuals, discovering things like whether or not this is something that they did of free consent, for example, or whether or not there are other aspects that ought to be taken into account to assess whether or not they are truly properly guilty of certain actions. So this usually looks like, no prison sentences or just limited amount of prison sentences, and then going to rehab centers, for example, that gives them the freedom to be able to enjoy and integrate into society. But it also deals with their inability perhaps to see and respect the uh, social and cultural norm of a society. So it transforms offenders into valuable members of society, prevents further offense by persuading the criminal that the action was wrong. Often people's actions were influenced by the environment, society, for example, growing up in a rough area, so the state has failed in order to provide safety within those areas, and thus then, given that the state has a duty or have had the duty of reparation towards the criminal, so that's why they ought to uh, make the arc of justice flexible, especially for those individuals, given that it is within their own field of preventing those things. Yeah, because so in regards to its application, I guess, so the law has mitigating factors. I guess I've repeated this word multiple times, but so it depends on your circumstances. If you suffer from unemployment, for example, obviously there are your circumstances will be taken into account by the judge or the jury, and then analyze whether or not these amount of years would be necessary to still be, imposed towards you. So that's why there are minimum and maximum prison sentences. The judge has some freedom in that to mitigating factors to reduce prison sentences, but it's not ultimate freedom, because there will be something that's dangerous if you don't have any form of accountability mechanisms towards judges. In its best case scenario, it might be the case that you can actually allow for more individuals to be free from not free, I guess, but to be punished with lesser sentences, especially for minorities who are over persecuted, etc. But it also opens up a huge gap in regards to the application of law and the sentencing of convicts, given that when we're talking about minorities, and in regards to social justice, obviously there are also another faction that would necessarily be the core of debate as well. So perhaps conservatives, not wanting to allow for lesser, not as harsh punishments for crimes, and not as harsh towards crimes. So in regards to that, then whether or not this is something that would be acceptable, especially in regards to the social context, but also whether or not that's something that is the best form of punishment per se. So it's fluffy to some extent. It takes some time to try to truly understand whether or not this is something that is, has any value, because I think in most instances, or like, I think just human beings in general are probably more inclined on a first impression basis to support retributive justice more. But that's why it can be hard to defend rehabilitation. But rehabilitation assumes that almost everyone is not truly guilty of their actions, and that they have been incentivized to do that, or coerced to some point to do that as well. But obviously there are problems with rehabilitation. Hold on. So practically, when it comes to rehabilitation, sorry, it, you know, so the idea that someone would repent from not being harshly punished, whilst is a noble and, seems like a very interesting idea, but I think when it comes to whether or not there's going to be repentance as a result of rehabilitation as the primary um, form of uh, sentencing or punishments towards criminals. So human beings react differently with their freedom being taken away from them, or with pain to some extent, perhaps not torture, but stripping away some form of freedom because of the breach of social contract, for example, and to indicate, to almost physically and explicitly indicate that this is um, deserving of X amount of years in prison, for example, with all your freedom taken away, your freedom of, not all, I guess, but almost all of your freedom taken away, and you being uh, put into uh, a whole system that deals with people like you who have committed some form of crime, um, to some extent is what can, better deal with the idea that someone would commit a certain crime, like recidivism, for example, committing a certain crime again. So it requires a certain level of pain inducement in order for people to know and realize that this is something that's not something they should do. So there are also proponents that thinks that people don't actually uh, are not just morally free of all forms of guilty actions. Obviously, some things are intentional and they had no other alternatives that they could have done, but still committed those actions and those wrongdoings. So in those instances, uh, you cannot simply disregard their intention and their guilty act and guilty mind in regards to that. So practically also would mean that those individuals would not learn from a more rehabilitative justice. Right. Are there any questions? Right, I guess there are no questions, so we'll continue. All right. And then there's also whether or not some rehab programs are better than others. Obviously, there's also the question of whether or not someone will be susceptible towards more rehabilitative punishments, whether or not it's truly possible to change the mindset of someone who have for so long internalized these values where their moral standard is one that does not match with the general moral standard of society. Whether or not it's possible for you to actually, I guess, nicely and morally indoctrinate them to think in other ways uh, to match your moral standard, and whether or not prisoners can necessarily be honest in regards to whether or not they have repented of their actions, because they can lie and you can't really know when they would lie and whether or not they would lie. So there's also whether, on the aspect of the whole purpose of rehabilitation, i.e. repentance and changing mindset of those individuals, people can just lie and pretend. So it might be a problem as well. That's why usually when it comes to the law, it's a combination of these things and it is applied on a case by case basis. And that's why it takes almost years for certain things to be prosecuted, for example, or for cases to be dealt with, because it takes a lot of time and a lot of resources to be able to reach this moral endpoint in regards to the principles of law, rehabilitation, retribution, etc. Right, and then There's also the aspect of deterrence. Deterrence, I guess, is more simple given that it's basically about preventing people from committing certain things. Oh, okay. Before that, I guess I'll answer Nat's question in regards to whether or not all these laws are set for adults only, or whether or not it can apply for minors. So when it comes to minors, so there are different levels to it. So in Malaysia, for example, for people, I'm not too sure about the exact age, but for people who were, if I'm not mistaken, 9 years old and below, they would be free of all forms of criminal intention. So if they are, perhaps caught killing someone or like selling drugs, they cannot be convicted and they will be free of all forms of criminal actions. For people above that age group, and then before entering into the legal age, the majority age, like 18 years old, for example, if you have committed a crime in that time period between 9 to 18, you can be recognized as having some form of criminal intention, but you'll be treated differently compared to criminals. In the last resort, or as a last resort, the most harsh thing would just be for you to be put in juvenile centers, for example. If it's a truly serious crime, then after you reach the age of 18, and you would continue punishment, real punishment for adults. But in most instances, it's not, because juvenile centers are probably more rehabilitative in nature. But I guess to some extent, it deters, especially for teenagers, for example, not commit some wrongdoings, because they obviously will not also want to be separated from their family. And so there's a transaction of their freedom being taken away at the point where they committed certain actions. So that's why it can also deter these teenagers, if we're talking about this slide I'm seeing. But in regards to the question, so it some laws applies indefinitely, some laws are applied like half sense, and then it's applied fully if you're an adult. So obviously there are, especially in regards to treatment of children, there are multiple special features that are implemented by the justice system, like the court, for example, for a trial that concerns a child. So for someone to be decided to be sent to a juvenile center, there are special requirements, like needing a female judge, for example, as well as the way that the prosecutors or the counselors, for example, can question the kid, the teenager that have committed that particular wrongdoing. So there are different ways that minors are protected within the justice system, because it assumes that they are perhaps half guilty of their actions, because they have not properly formed their moral compass yet, etc., because they haven't reached the average age of someone achieving mental not awareness, but maturity. So that's why it applies differently. So I guess the simple answer is it applies differently for minors, and within the minor age group, there are also divisions between whether or not some laws are applicable at all. All right. Right, thanks for the question. After deterrence, let's take a 5 to perhaps 10-minute break. I guess 5-minute break will be enough. We'll take a 5-minute break, and then we'll come back to continue with the lecture. There will be, I think, 2 more principles and purpose of the law that we'll be discussing. All right, but let's finish deterrence first. All right. So I get the concept of deterrence is simple. It's basically imposing what is conceived as a sufficient criminal sanction or penalty to be able to prevent individuals who might think the same way as criminals into committing those actions. So perhaps that they are fearful of a certain their freedom being taken away, or like some form of harm towards their livelihood and their freedom. So it's to be able to prevent this criminal intention from happening and thus leading to criminal action. So it's the question of what would be enough to punish some individuals. Can stealing be punished with the harshest form of punishments and criminal sanctions? Whether or not they should be that their hands should be cut off or something like that, just so that you are able to prevent those harms from happening. So in the practical sense, it might be the case that you are going to 100% prevent stealing, but it doesn't answer the question of whether or not it's something that's proportionate as something that perhaps is necessary, given that you want to disincentivize criminal behavior, but whether or not this is something that you are justified to do, and in terms of proportionality, whether or not it's proportionate. So when it comes to again punishment for stealing, then perhaps there'd be lesser sentences. Maybe you would concede and trade off 100% effectivity of the law in preventing certain crimes, but it does not necessarily mean that that's something that the law can do or is justified to do. So it's basically setting an example society, to send the message that you cannot do this and you should not do this, but if you do this, this is what will happen to you. Be sent to prison if you do commit certain things. All right. But obviously there are problems with deterrence as well, as with any other ideas out there. The problem with deterrence is that many criminals actually don't consider the consequences of their actions. What it means by this is, so again, when we're looking at what makes a crime, it requires a guilty act and a guilty intention, a criminal act and a criminal intention. But many criminals don't actually consider the consequences of their actions at the point where they committed certain wrongdoings. Sorry, hold on. Can you hear me? All right. Can you hear some background noise? My niece and nephews are fighting. Okay. Those weren't barkings, those were my niece and nephews. Okay. Give me a second. Okay. There's some background noise still, but I hope it's more manageable. Right, so we're talking about problems with deterrence. So we were talking about many criminals, how a lot of these criminals don't actually consider the consequences of their actions. So the mental calculus of someone committing a crime, when they were committing that crime, obviously they were not thinking about, oh, I'm going to serve 5 years if I were to commit this criminal wrongdoing. Obviously, those things does not come into the minds of those individuals, given that to some extent most crimes are not most crimes, but there are crimes that are passionate in nature, but like revenge, for example. Obviously, at that point of time, the mental calculus of these individuals don't necessarily consider the deterrence part, because in that instance, your mental state is different. Maybe that you are
desperate or you are vengeful, for example, you want to take revenge to someone, so you don't care about being punished. So for those individuals, then deterrence don't work because, and if we were to assume that it's true that most people, when they are committing a certain crime, don't actually think about deterrence, then it does not mean that it actually prevents someone from doing certain things. So that's the idea of uh, whether or not this will be applicable for criminals, for example. And it's also that often it is merely the threat of being caught rather than the severity of the punishment itself, given that the state cannot be, uh, a state that is able to effectively 100% control crimes, for example. Obviously, there will be some that will be, um, you know, able to shy away from the light of justice. Um, so at that point of time, the message that you're sending is that this could happen to you. So it's a threat that you perhaps might be caught, but obviously you have to be caught first. And for people who, know that they are perhaps going to suffer from their freedom being taken away, for example, as a form of deterrence for certain actions, obviously they're going to, innovate when it comes to their criminal action. So hiding evidence, etc., etc. So for those groups of individuals, deterrence also don't work. Um, right. So again, indeed, making punishment large enough uh, so that it balances the utility of committing the crime often makes it a disproportional and unfair punishment, given that perhaps you can prevent those things, but you obviously would have to assess the weight of the utility of the 100% prevention of this one crime compared to the uh, the abuse of human rights, the freedom to be free from torture, for example, and to have full autonomy over your life, and how that also necessarily extends to um, uh, life as an inalienable form of freedom that cannot be taken away and should be respected in all forms of circumstances, even when someone have committed a criminal action of the worst kind. So even in those instances, deterrence does not necessarily capture the whole problem of whether or not this is something that's going to be proportional. Obviously, there's a balance to everything. So, okay. After this will be incapacitation. This will be just like in the sense of more brutal and barbaric forms of punishments. But before that, we'll take a 5 minutes break. I guess we can reconvene at 8:10. Is that okay? All right. Now we're going to look at incapacitation. Sorry, ignore the first line. So it keeps the idea of whether or not it keeps criminals away from society to a point that society will be protected from their misconduct, the protection of society in general, given that you are tucking away this person who have committed wrongdoing and who might do this particular wrongdoing again in the future to some extent. So society in general knows that they are safe from those individuals, if to some extent, or it is that the state is doing their job in terms of providing that protection. There's an obvious utilitarian benefit, given that it's about protection and safety and what that means for people if they are not ruled by fear of being murdered in the street, for example. But obviously, there are also problems with incapacitation to some extent. It's that you gotta let them out at some point, or maybe if you don't, that would be not a moral thing to do, given that morality and law is one that's interconnected with one another. If a large majority of society thinks that that's something that the state cannot do and does not have the right to do, and is inhumane towards the treatment of those convicts specifically, also obviously you have to release them, and that would be in the majority of circumstances. So obviously you got to let them out at some point. So it's not as if that you can permanently segregate those individuals into and put them in another island. They will never come back, for example. Obviously, they will have to come back given that they are part of your society. Sorry. And then obviously it's also same thing. It's clearly not absolute, or it'd be cutting hands of thieves as per the previous example, or at least giving them the option so that, you know, perhaps they would not commit certain actions again if they were to agree to these things. But obviously that's not a question of um incapacitation only. It's also about the rights of these prisoners, whether or not they enjoy the ability to decide for themselves, whether they coerce making those decisions, according to their desperate situation, from, you know, their freedom being taken away, whether or not this will amount to clear moral judgment in regards to themselves and what's best for themselves. So what happens if you give them the option? An exploration in regards to the context of a debate would be whether you know, you give the option to prisoners to voluntarily be part of human trials, for example, or for drugs, for example. So in exchange for shorter years served in prison. So whether or not this would be not only a moral thing to do, but the freedom of prisoners and the protection of some form of freedom that they still deserve, whether or not this would be just for them. Given that when it comes to a crime, not only that you have to be just towards the victims, but also just for the victims, but also just towards the perpetrator or the criminal. Right. And then, so this would not, I guess it is to some extent for criminal actions, either paying a fine, etc. And especially, I guess, white collar crimes. So the concept of restitution is more, you know, more applied in regards to that. But again, apart from criminal actions, it can also be the civil aspect of sanctions. So you know, when it comes to perhaps, you know, a breach of contract or a breach of duty of care, for example. So restitution is basically paying back that amount of money in exchange for either, you know, the cost that can be connected towards that particular criminal action, or you know, just in terms of the mental state of individuals who are probably traumatized, or some form of, you know, criminal harm towards a person, and then for that then to be used as a standard to punish someone, i.e. to financially incentivize them to not commit certain actions. Can the people negotiate the compensation? Um, so there's a difference, right? So when it comes to negotiating the compensation, usually that can happen in the civil court or for civil conflicts, because it's about two parties coming together and trying to, you know, say to the court that this person has committed a wrong, and then one person says, I did not commit a wrong. But in those instances, you can negotiate compensation. Either you can carry out of court settlements. So we discuss if you don't want to be legally sanctioned to do something, so perhaps you want to just settle it in other forms, like perhaps money. Usually it's money. So in those instances, you can negotiate the compensation. So in civil conflicts, you can, but for criminal conflicts, you can't negotiate a compensation. Usually, it's you know, more applicable to judge. But obviously, there are discussions regards to sentencing, and you can, you know, provide mitigating factors for certain crimes, and the financial punishment for a certain individual. So, you know, either in the form of bail, for example, or in the general sense of punishment, or maybe what's that thing? forgot the word of it for it. Yeah, never mind. But yeah, it's basically that for criminal actions, it's not applicable. So you can't necessarily negotiate the compensation, but you can prove mitigating factors. So for those mitigating factors, takes into account your background, etc., etc. So in that instance, the idea of restitution would, I guess, not be strictly applied to you because it takes into account your background, and I guess that is also a form of negotiation to some extent. So yeah, basically that. Okay, now we'll continue. But obviously there are also problems with restitution. It keeps the criminal in contact with the victim, and to some extent continuing the psychological hold on those victims. Given that sorry, if you were to have been a victim of a particular crime and to have been mentally tortured and traumatized, to have suffered those harms, and then to relive your trauma and that hurt at the point where you are triggered by seeing this person or seeing this person talk about the things that they've committed to you and how damaging that can be to you as a person. So when it comes to restitution or with conflict resolution, when it comes to, especially when it comes to a criminal action or a total crime of a civil conflict, would mean that you allow for the psychological hurt and injury to continue, to see that perpetrator again. So there's also the aspect of when it comes to there's also the aspect of when it comes to the way that victims ought to be questioned in court, the conduct of solicitors or defense counsels, or even the prosecution, for example. There are some form of also limitations towards the area that they can poke holes into, or cross refer in the sense of evidence, for example. But this is a practice that I guess would be not observed in the fullest sense, because there are still argumentations in regards to that supports the idea that the victim is still part of the crime, and the whole culture of victim blaming, for example, that will also allow for the psychological hurt to continue, especially in court, especially when the law should have been the protector of those individuals, but instead it is now actively injuring those individuals when they are trying to argue for justice, or when they want justice for themselves, they have to be heard. So that's also the problem with restitution. Right. So that actually marks the end of this lecture. Are there any questions? There's 9 minutes left in regards to the lecture, so we can now focus more on questions. Is it a strong enough argument to say that penalties can also cause criminals to be more careful or skilled about their crimes and thus harder to track, or is that too situational for deterrence? Okay, hold on. Right. So the idea about whether or not it's applicable to a person to be able to deter them from doing certain criminal actions, and when you're trying to analyze the rational calculus or the mental state of the specific group of individuals at the point where they are committing a crime, I guess it depends on the context, right? So if maybe truly it's a valid judgment of the concept of deterrence in law, and plus then one side have to support deterrence and one side have to not support deterrence but support other forms of justice or forms of punishments for the purpose that punishments will serve. So it all depends, I guess. That would be my answer. But in the form of a debate, whether or not it's a strong enough of an argument to say that it can cause criminals to be more careful or skilled about their crimes, and thus making it harder to track. If properly extended and argued, I think it can make sense. And maybe it's situational, but it's an instance that carries a huge degree of harm that um, uh, warrants its warrants its application, or warrants the harshness of its application for deterrence. So what would be an example for this? I guess an example for this would be, I guess a classic example would be things like drugs, for example. Making drugs illegal, so that you have punishments for drug possession, drug dealing, etc., would mean that you have to, deter those individuals with quite harsh manners based on the amount of hurt and injury that it can cause to victims of drug abuse and people who have become addicted to drugs, for example. And it creates this whole other problem in regards to social ills, etc., etc., etc. So it applies to mental health. It applies to um, what's that? Yeah, applies to almost everything in society. So in those instances, it might not be the case that the state should carry out those harsh punishments. So perhaps they might want to decriminalize drugs. And that's why, in the context of the decriminalizing drug abuse, for example, would mean that there's lesser deterrence. But given that the problem deterrence is that it doesn't necessarily take into account the consideration of those individuals, but also their background. So in those instances, it doesn't matter if this criminal were to be, if there are harsher punishments, that they will be more careful and skilled. But because in the context of drugs, then maybe they, sell, or they already are selling in the black market, but, maybe even for the hiding of those criminal actions. But if you to decriminalize it, then it makes it clearer to the general society, and that individuals, especially the victims, are not going to be harmed, and that these individuals should not be considered as criminals, given that they're victims of circumstances. But again, when it comes to the concept of deterrence, it doesn't necessarily take into account the background of those individuals, and that's why it's a problem. And obviously, obviously this is a valid statement, but so you can argue it, but there's always going to be an inverse towards that particular argument as well. Yeah. Does that answer your question, Chloe? All right. Any other questions? Right. If there are no more questions, since there's only 4 minutes left, yeah, I think you are going to have access to the recording. Surabi, can you confirm that? Yeah. I'll also send the slides later. All right. If there are no more questions, I guess that's it for tonight.